65 years ago today, the Supreme Court ended racial segregation in schools with a unanimous, as in 9-0 decision in the landmark case of Brown versus the Board of Education. For 65 years, it's been the law of the land that separate but equal is unconstitutional. So why now are we suddenly hearing this?
Ms. Vitter, do you believe that Brown versus Board of Education was correctly decided?
Senator, I don't mean to be coy, but I think I get into a difficult area when I start commenting on Supreme Court decisions which are correctly decided and which I may disagree with. Again, my personal political or religious views I would set aside. That is Supreme Court precedent. It is binding. If I were honored to be confirmed, I would be bound by it, and of course I would uphold it.
So you believe it was correctly decided?
You know, Senator, as a judicial nominee, I think it's not appropriate for me to comment on the correctness of particular precedents. I would faithfully follow them if I'm confirmed.
Was Brown versus Board of Education correctly decided?
Senator, I don't think that it would be a productive exercise for me to go through the most thousands of Supreme Court opinions and say which ones are right and which ones are wrong.
Senate Judiciary Democrat Richard Blumenthal has been making a point of asking Trump's Judicial and Justice Department nominees to answer a question that should be a no-brainer. Was the Supreme Court right to strike down the separate but equal doctrine 65 years ago today? And lately, a whole slew of nominees have been dodging that very question. Yesterday, the Republican-controlled Senate confirmed one of these nominees, who you just heard about, Wendy Vitter, to the lifetime position of federal district court judge. And by one count, there are 24 more nominees on deck for confirmation who have also refused to say whether Brown versus Board was correctly decided. Senate Majority Leader Mitch McConnell has said that given the choice to pass a bill or confirm a judge, he'd confirm a judge. That's how committed he is to reshaping the courts. He's made it a priority, and so the Senate is moving at breakneck speed to make that happen. But Democrats and many legal experts are alarmed at what they're hearing from people who are on track to get those seats, like civil rights attorney Sherrilyn Ifill, who set up a big red flag in a Washington Post op-ed, quote, "Brown should be regarded as a low bar to clear for any judicial or Justice Department nominee. That scores of Trump nominees have been confirmed despite a refusal to even approach this simple question is a shameful reminder of how far we have moved away from principles that once enjoyed broad consensus in this new normal." Nominees either support Brown, the rule of law, and equality under the law, or they do not. And if they do not, they put our very democracy at risk. Joining us now, Sherrilyn Ifill, President and Director Counsel of the NAACP Legal Defense and Educational Fund. Ms. Ifill, good to see you again. Thank you for joining us.
Thank you, Ali.
What do you make of Senator Blumenthal's strategy by asking this question of Trump judicial nominees?
Well, it's funny, Ali. We were with Senator Blumenthal yesterday on Capitol Hill. We had a rally to commemorate the 65th anniversary of Brown. And he confirmed what I actually believe to be true. He confirmed that there was no strategy. The question, he thought, was a simple one, a kind of softball, giving a nominee an opportunity to kind of talk extemporaneously about issues of race and equality. He actually was stunned when the first of these nominees, Wendy Vitter, gave the answer that she gave, and you played the tape. And he has continued asking the question because of what Wendy Vitter, how Wendy Vitter responded, and then Andrew Oldham, who you also showed in the clip. And what's become clear by this succession of Trump judicial nominees answering the question in this way is that this is not an accident. This is orchestrated. What is critical for viewers to know is this is not the norm. This is not a conservative liberal thing. Conservative justices have been asked this question in the past, particularly justices nominated to the United States Supreme Court, and they have answered the question. They have chosen not to answer, for example, questions about Roe versus Wade, but they've always answered questions about Brown. Chief Justice Roberts talked extensively about Brown at his confirmation hearing. Justice Alito at his confirmation hearing described Brown as vindicating the true meaning of equal protection under the 14th Amendment and the guarantee of equality for all races. Justice Kavanaugh, last year at his confirmation hearing, described it as the most important case in the history of the Supreme Court. So it's not as though this has been some line in the sand of conservative ideology. Something new has happened. And what we are seeing from these judges, beginning with Wendy Vitter last year and other nominees, including the Deputy Attorney General, who was just confirmed yesterday, is a decision to refuse to endorse Brown, which used to lie at the center of the canon, the center of the consensus within the legal profession. And we should take note of the fact that there is a concerted effort to move Brown to the margins.
To what end? Are these judges who do not believe that the doctrine of separate but equal is invalid? Are these judges who one day might take a chance of overturning this landmark ruling?
Well, that's why you ask the question, because you really want to understand what do they think? Is that what they think? Chief Justice Roberts felt comfortable talking about Brown, he said, because he put Brown in that category of cases like Marbury versus Madison, the 1803 decision that established judicial review. He put it in the category of cases like Marbury that were unlikely to ever return to the Supreme Court. So that's what Chief Justice Roberts thought in 2005. Are there now members of the legal profession who believe that Brown, the question of whether state-sanctioned apartheid is constitutional or not, that believe that that's an issue that might return to the Supreme Court? What possible reason could one have not to answer the question? And I do think it sends a signal. There's some signaling happening that everything is on the table. And it's important for people to remember that Brown wasn't just about school desegregation. What Brown symbolizes, I think, for many people, particularly on the far right, is kind of an entire project that transformed our democracy. And it's a project that opened the doors to groups, to African Americans, to Latinos, but also to women, to members of the LGBTQ community. It was a new way of reinvigorating what the meaning of the 14th Amendment and equal protection meant. And there are many who are in opposition to some elements of that. And by simply refusing to talk about Brown, it sends a signal. It's a flare. It's a shot across the bow, in my estimation, that we should not ignore. And we should not have a failure of imagination with anyone proposed by this administration that they might carry some quite extreme views.
Speaking about a failure of imagination, Sherrilyn Ifill, every time I speak to you, I get smarter about something. I have to say, this wasn't a topic I knew I needed to get smarter about. So now you know. Sherrilyn Ifill is the president and director counsel of the NAACP Legal Defense and Education Fund. We appreciate your time tonight.
Thanks.
Much more ahead, including a letter of the strongly worded variety from a politician who's not playing around. Stay with us.
Hey there, I'm Chris Hayes from MSNBC. Thanks for watching MSNBC on YouTube. If you want to keep up to date with the videos we're putting out, you can click subscribe just below me or click over on this list to see lots of other great videos.